Very many people get irritated when they get their landlord coming into your private house. You have an office, you have leased an office from somebody. Do you know the landlord, the landlady has a right to come and inspect? Yes, but the landlord and the landlady must give a notice of 7 days. One of the biggest issue is unpaid rent or unpaid amount or consideration that you agreed. If payment was weekly, 1 day extra, the landlord has an obligation to terminate. If it is monthly, failure to pay rent, don't come to lawyers. If you have no rent, the landlord will terminate that lease. Welcome to Court Helicopter Weekend Explainer. This is episode 7. We agreed by the board of Court Helicopter that we'll do 28 episodes on the land law. So this is a build-up on the other episodes that we did. Today, we are dealing with the leases. A lease is defined by law to be where somebody has been allowed to use another person's premises or land for a specified time with certain conditions and obligations on the one who has been given to use that land or that premise. So, what is very critical in a lease are the following factors that we look at. That is, Section 56 talks about the power to lease land. If you have a land, that land, you can lease it to somebody. It still remains your land. If you have a building, either commercial or residential, people are staying in leased houses. You are a tenant. You can lease that land, that premise. So it is the question about ownership does not change, and you have a right under the law to do that. Then we have Section 57 talks about periodic leases. These are leases below 2 years, where that lease operates by the payment of a certain consideration. This payment can be according to Section 57 1B. The term is from week to week, month to month, year to year, or any other periodic basis to which the rent is payable. Those are periodic leases. When you want to terminate the lease, and this is where people get a problem, when you want to terminate the lease, you have got to give a notice of not less than 6 months. It says, if it is for land, agricultural land, the leases others for buildings, for others, you can terminate within 30 days or within 2 weeks. But kama umepea mtu shamba ya kulima, and I know very many people in the diaspora, you have given people land. You have leased that land for them to do agricultural land. You must give that person a notice of 6 months. What is the logic behind it? He has planted his sukuma wiki. She has planted her crops, her bananas. So you must give sufficient notice of not less than six months. What about these other periodic leases? You can do it as the law provides. Then we have what is called those leases that don't have agreements, written agreements. We niangalilie hiyo shamba, utakuwa unanilipa pesa ngapi? 2,000 shillings every year, sawa. Those are also called leases. Then we have all these other leases. You have got to give a notice if you want to terminate of 30 days. Don't walk and give your tenant, don't walk and give somebody you have leased your premises a notice that is not less than 30 days. That is provided for. Then we have those leases under Section 58 called the short-term leases. These are leases that are below 2 years. They are made for 2 years without an option for renewal. So, a short-term lease may be made orally or in writing, so long as the duration is below 2 years. That is the law that is there. Then, a short-term lease is not registrable interest in land. These leases are not registered. They are not taken to the land registry. But if your lease is 5 years and above, if your lease is more than 2 years, that lease must be registered at the Ministry of Lands. Then we have what is called, what is the covenant? In a lease, there are obligations for the owner. The owner has an obligation to make the property good, to make the property habitable, to allow you the private occupation of his property. You, the one who has leased the property, you have a duty to pay that amount that you agreed. If it is monthly, if it is quarterly, if it is annual, you have got to pay. You have got to take care of the property properly. Those ones are captured under Section 65. Suppose the property that you have been given, the land that you have been given, the premises that you have leased is made impossible to use. That is captured under Section 65E. If the leased premises or any part of them are destroyed or damaged at any time by fire, by flood, or explosion, or other accident not attributed to negligence on the part of the owner, or by civil commotion like maandamano, or by lightning, storm, earthquake, volcanic activity, or other natural disaster, what happens? If the property will not be ready for occupation within 6 months, the person who has leased has a right to terminate. Whether you had 5 years, if natural calamities happen for 6 months, the landlord or the owner does not, you will have a right to terminate whether you had signed that lease for 7 years. But a caution, you will still be paying rent. Even if the property has been destroyed by fire, you will pay rent for 6 months. Then, if the owner fails to return that land or that property into proper use, then you will proceed. Then we have G. At that time, you have got to continue paying the taxes, you have got to pay the rates and all the outgoings in respect of the leased land, except to the extent otherwise specified in the lease. Then very many people get irritated when they get their landlord coming into your private house. You have an office, you have leased an office from somebody. Do you know the landlord, the landlady has a right to come and inspect? Yes, but the landlord and the landlady must give a notice of 7 days before they can come to check their building, whether the paint has failed, whether the lighting is working, whether the sewage is working, whether you are making changa, you have turned the premise into a factory of cocaine. So the law says that the landlord can enter and check. If the landlord finds out that there is a problem, the landlord can terminate that lease. When can the landlord be allowed to terminate a lease? And what are the grounds? One of the biggest issue is unpaid rent or unpaid amount or consideration that you agreed. If payment was weekly, 1 day extra, the landlord has an obligation to terminate. If it is monthly, failure to pay rent, don't come to lawyers. If you have no rent, the landlord will terminate that lease. That is an obligation on your part. Section 66 and looks at some of the leases. You've been given a building, you sublet. You bring Vivian, I've taken a big portion, chukua hii weka kinyosi, na wewe chukua hivi, munanilipa rent, I paid the landlord. Most leases that are written, you are not allowed to sublet. Unless, if you have that in mind, make sure the agreement that you enter with the landlord or the landlady has a clause that says you can sublet. And also, if it has conditions, a clause that you can sublet, it must be specified what you can sublet your building for. But most of the leases, nobody will allow you to sublet without their authority. That is what section 66, 67 talks about. Then we have, can you transfer? Under section 68, can you transfer a lease to somebody? It is called an assignment. Yes, the law allows, if Cyrus took a lease from Bramwell and Cyrus is living to the US and he took a lease of 5 years, he has gotten a green card. Remember, this lease cannot be terminated. It must go full term, especially commercial leases. If in the agreement there is a provision for assigning, then he can transfer that to Vivian. But if it's not there, and that's why we are saying you must be very, very careful, you will continue paying, whether you have gone to, whether you have moved to abroad and you are not available in this country. What are the rights of the person who has been transferred a lease? We said this lease belonged to Cyrus. He has transferred to Bramwell. Bramwell takes all the responsibilities. He'll continue now paying. He will be operating as a new person who has been given that lease. There cannot be any variation of that lease. So that one is there. What are the issue of forfeiture? The leases can be forfeited if these grounds are found. One, if one commits a breach or omits to perform an agreement or condition on his part. 2, if the lessor has been adjudged to be bankrupt, or if the company has gone into liquidation. If you have been, the court has found you to be bankrupt, the lease will be forfeited, and that is a position. And Section 74 says once the forfeiture has been done, then the lessor is allowed to go. What are the lessons in leases? The lease is a document that you need to have. Very many people, especially business, you are not supposed to enter into a commercial business premise without a lease. Si mambo ya mudomo. Have a lease. 2, take that lease to your lawyer, because you're not a lawyer to understand the clauses in those leases, so that the lawyer can advise you whether the clauses in that lease favor you as a tenant, favor you as somebody who has hired or leased that premise. 3, ensure every page of the lease document is signed. Normally, you sign the last part. The landlord changes and inserts new pages, and a dispute arises. Did you sign page 2? So the lease must be signed by you. The lease you must sign, and the landlord must, or the landlady must sign it, both, every page. Put your initials present, and the last part you sign there. 3, ensure there is a witness. Ensure there is a witness. Lastly, make sure you have a copy. Make sure you have a copy. Whenever there is a dispute, you have your own lease. And of great importance, from court helicopter, ensure that you follow the terms and covenants in that lease. How to pay, when to pay, what are the obligations of you, and what are the other obligations. Of great concern is about service charge. It is a clause of service charge. Very many of Kenyans don't understand what service charge is. In the lease agreement, you'll find out that there is a service charge. The landlord will be telling you, you'll pay for your water, you'll pay for your electricity, you'll pay for your DSTV to watch World Cup, but again you'll be paying to the landlord every month or every quarter what is called service charge. Service charge is the amount where the landlord has hired people to clean the common areas. If you are staying at the apartments, the stairs are not cleaned by you. The lift is not maintained by you. The water used in the common toilets is not paid by you. The parking lot, the cleaning of the parking lot, if you don't pay for parking, that is service charge. The borehole, if you are not being charged for water, that is what is called service charge. The lighting at the security lights, at the staircases and the parking lot, the watchmen, the cleaners, and all those issues are captured in our lease documents. Make sure you read and understand what you commit yourself to. Failure to which, the courts will not help you. From court helicopter, you now understand why we made this issue about land a very, very, very serious issue. For example, if you do not pay Remember, we did an explainer. Failure to pay, you have lost. In leases, you must pay. You'll be thrown out and you'll be crying to the court. You'll not be assisted. Wakili Danstan Omari.